SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. Welcome to this current affair class. This is the next current affair class on a very important topic. Class number 16. I am Mayank Bharadwaj presenting you this class, and this will be important for your upcoming prelims examination. Supreme Court has said something about the anticipatory bail and also about something related to the SC/ST Act. So not every insult against SC/ST persons can be considered as an offence under the SC/ST Protection Act. We all know SC/ST Protection Act is there of 1989. So let us try to understand this whole concept of what has actually happened. Now the key judgment is there was a two-judge bench which was constituted and said that whatever bar section 18 puts on section 438 of CRPC will not be available if there is no prima facie content available to point out that a commission of an offence has been done. Okay, now let me simplify all this. Anticipatory bail. This is a very important provision for civil liberties in India. Anticipatory bail simply means that before you get arrested, the court grants you bail. इससे पहले कि पुलिस आपको पकड़े, अरेस्ट करे, अगर आप कोर्ट पहुंचते हैं और कोर्ट if they give you or grant you the anticipatory bail, of course not in heinous crimes, not in cognizable of, can be done in cognizable offences, but of course not done by court in special laws like UAPA or in heinous crimes. But anticipatory bail can be given because sometimes a person who is arrested not necessarily have committed the crime, and that is the reason why anticipatory bail is given. And anticipatory bail is one of the most important aspect of civil liberties in India. So the provision of anticipatory bail is given in section 438 of CRPC and the new BNSS Act section 482 in BNSS, Bharatiya Nyaya Suraksha Samhita. Now anticipatory bail can be given under these two sections. Now section 18 of the SC/ST Act, it bars the anticipatory bail given under section 438. That simply means any offence is committed where an arrest has to be made or allegations are made under section of the SC/ST Acts. According to section 18 of that particular act, anticipatory bail cannot be given to the person. So simply means that if a person, if anybody commits any crime against a person from SC/ST community, anticipatory bail cannot be given to that particular person. Okay, I hope you understood this. One more thing, court said that the bar on anticipatory bail is allowed when section 41 of CRPC is applied, which is read with section 60A. Now section 60A says that any arrest of any person made by the police officer has to be made according to law, and in this case the law is CRPC according to this code, as it says. Section 41 says that the arrest of any person can be made by the police officer in cognizable offences without warrant. So section 41 gives the power to the police officer to arrest anybody without warrant. But if you read it with section 60A, that the arrest has to be made according to the code, according to CRPC. So in these cases, the anticipatory bail can be barred. But in all other cases, even if the allegations are made under the SC/ST Act, there has to be some sort of prima facie material available for the anticipatory bail to be cancelled. कहने का साफ मतलब है कुछ तो होना चाहिए ये चीज देखने के लिए कि सही में कोई क्राइम कमिट हुआ है या नहीं. अगर सिर्फ एक कंप्लेन के बेसिस पे किसी को एंटीसिपेटरी बेल नहीं दी जा रही है, सो इन वन और द अदर वे इट इज इन्फ्रिंजिंग द सिविल लिबर्टी ऑफ द पीपल. So I hope it clarifies your doubts around this subject. So section 18 of SC/ST Act, as we have seen, it excludes the anticipatory bail under section 468. Supreme Court ने जो clarify करा वो क्या है? Courts must verify the allegations made. कोई भी allegation which are made against a person under SC/ST Act of 1989 has to be confirmed by the courts. Okay, whether that allegation is true or not, some sort of material which proves the allegation correct has to be presented in order for the anticipatory bail to be cancelled. Not automatically it will be cancelled. ऐसा नहीं है कि section 18 में लिखा हुआ है कि section 438 of CRPC will not be applied to the cases of the SC/ST Act, तो anticipatory bail लागू ही नहीं होगी. होगी, but उसके पहले कोर्ट्स वेरीफाई करेंगे. कोर्ट्स ये वेरीफाई करेंगे कि वेदर देयर एग्जिस्ट्स सम मटेरियल व्हिच प्रूव्स द एलिगेशन और नॉट. अगर एलिगेशन प्रूव ही नहीं हो रहा है, इफ देयर इज नो मटेरियल अवेलेबल, देन द एंटीसिपेटरी बेल कैन बी गिवन. दिस इज अ स्टेप टुवर्ड्स सिविल लिबर्टीज एंड अपहोल्डिंग ऑफ सिविल लिबर्टीज. नाउ केस, this was the case. Sahajan, he was, who is he? Now, he was a Malayali YouTuber news channel speaker, and he has said something derogatory against the CPM leader and the Kerala MLA PV Srinijan. So he said something which was derogatory, which is considered derogatory, but he was given the anticipatory bail. Why he was given the anticipatory bail? For the same reason, no prima facie material is available. If the prima facie material would be available, then the anticipatory bail would not have been given. Very simple to understand. So Supreme Court का decision क्या है? It granted the anticipatory bail as prima facie case was not strong. There was no material which can be considered as an important material to lodge a complaint against that person. Or even if the complaint is lodged, further investigation or interrogation is required, but the anticipatory bail should be given. So what is anticipatory bail? We have already seen section 482 of the BNSS and 438 of CRPC allows a person to apply for bail before arrest. Before a person gets arrested, you can be freed. Described as an important aspect of personal liberty. We've already seen this. It protects the individual from unjustified humiliation and harassment. So many important things are happening because of the anticipatory bail. It's a very important provision of law. Court must balance rights of the accused and victims. So a balance has to be created. Anticipatory bail should not, reflect some sort of injustice happened, some heinous crime has happened, or any special law under which a person has been booked and the court gives the anticipatory bail. That is also not good. So bail is rule and jail is exception, but in heinous crimes, but in crimes related to anti-terrorist activities under UAPA, that thing is not accepted by the courts. Their court says that the bail is an exception because the acts done are anti-human and inhuman. So conditions for granting bail, what are the conditions? That there has to be some reasonable apprehension in the mind of the accused that the arrest can be done at any point in time. Several conditions are that they must cooperate with the police in investigation. Along with that, they cannot leave the country without telling or without informing the police, and bail can be cancelled at any time. They can be called back to custody, police custody or judicial custody at any point in time by cancellation of the anticipatory bail. So these are few conditions which are available for the anticipatory bail to be issued by the courts. Types of bail under CRPC. Very simple. Regular bail which you get after the custody, means a person is in custody for n number of days and then the person applies for bail and he gets it. Okay, the person must not be kept in jail if there are too many days still left in investigation, or the investigation has to be too long and charge sheet is yet to be filed, which will take so many days, and the person has not committed some heinous crime. At that point in time, bail can be given, and that bail is regular bail. Interim bail is the temporary relief which you get just before the main bail application is in front of the court, and anticipatory bail is the pre-arrest bail. We have already seen this. So there are few cases in state of Rajasthan versus Balchandra in 1997. The court said that bail is rule and jail is exception. In the trial, if the person does not have the capacity to influence the trial in his favor, okay, and the person has not committed some heinous crime which he may repeat if he is set free, at that point in time the person should be given bail, because he has not been sentenced to imprisonment. The trial is still not complete, the judgment has yet not came, and the person in trial may be proved and can be proved as innocent. So why to keep the person in jail? There is no meaning of doing it, and that is the reason why the person should be given jail, and jail should not be a rule but should be an exception. But jail is an exception in cases which are anti-terrorist or which are heinous. Shift burden of proof onto the accused, and bail denied if prima facie evidence exists in UAPA, Unlawful Prevention Act, Activity Prevention Act. So the conclusion is that if all the ingredients of the offence exist, anticipatory bail can be given, and it ensures the protection of the SC/ST community without the misuse of the law. Several times misuse of the law is also done just to harass a person, and there are provision in law such as section 18 we have already seen, which bars the anticipatory bail given under section 438 of CRPC, but that is no more applicable after the court's interpretation that in order to give anticipatory bail, the court must verify the allegations, and if there is a prima facie evidence or prima facie material available to prove that the allegations which are made are very much true, then the anticipatory bail will be cancelled, or else the anticipatory bail will be given to the accused. What is the significance? It upholds the fairness in criminal justice system. So thank you very much for joining me in this video. There are few important provisions such as Article 21, few sections of CRPC which are very important, and the article on civil liberty, if you see, right to movement, right to have free speech and expression under Article 19, which are very important here, because anticipatory bail is an important provision of civil liberty, and anybody can be arrested on any allegations made by somebody. Now it is upon the court to actually investigate the matter in such a way that the truth comes out, whether the allegations which are made are true or not. There must be some material available, and the police authorities, the authorities which are making the arrest must also come up with these kind of evidences, so that a person who is innocent is not harassed as per the law. That is what is rule of law in simple terms. So thank you very much for joining me. We will be coming with next topic in the next class, and bye bye. Jai Hind.